live.
We are live.
All right, we're back in Senate Judiciary. We have S-151 and Adam McCrasson here to testify.
Thank you, Mr. Chair, members of the committee. Adam McCrasson Group here for the Vermont Association for Justice. We are familiar to you as kind of keeping an eye on tort law, which is the area of the law where when people are injured and they seek access to justice from the party that hurt them. Appearing on S-151 to articulate some grand concerns with the legislation. I will, at the top, try and summarize and then move through kind of a few key touch points. Who is rights are being impacted in this bill and what's kind of happening now. Talk a little bit about how litigation is a bummer for all parties involved and how discovery works. Really ground the conversation in the anti-SLAPP law, which this is a derivative of, and then articulate reasons why it's an odd fit to bridge over into access to insurance for people that have been hurt by a careless actor. The kind of top line for you on this is this bill is a novel approach with sweeping implications that would result in denying access to corporate entity level insurance, leaving people hurt by carelessness of an actor without a remedy. And point number one, just to address a few key things at the top. When we hear concerns about frivolous litigation, please know Rule 11 is in place now. Judges have authority to dismiss and sanction attorneys that bring frivolous cases. And so we aren't, as a state that is among, if not the least litigious in the nation, we do know that judges have Rule 11 there to address any frivolous lawsuits. So, all right, some examples. What are we talking about? A car crosses the center line and hits another car. The people in the car that get hurt now are going to seek access to insurance to cover their lost wages, their medical bills, and so forth. This bill would have it be that if it turns out that vehicle was driven by a volunteer, well-intended driver, the victims of the accident would face an insurance company going to court right away saying this case needs to be dismissed because the statute now says on page 3, the court shall grant a special motion to strike. This is an immediate dismissal of a case if the alleged harm was caused by the defendant's gross negligence. Now, please understand, the victims have really no interest in pursuing the driver, the volunteer. This is not about, often we're here talking about corporate accountability and holding wrongdoers accountable. This is not that at all. This is a situation where distracted driving has resulted in people being catastrophically hurt, and whether they deserve access to entity level insurance that is there for the purpose of their recovery. My phone blew up yesterday with examples, and I know not to wade into the litigation that was brought from the proponents of the bill and kind of go into all of that. I know not to engage these findings that are kind of a little foreign to what we know as how things work in Vermont. I am here with attorneys who have small children who have plunged to catastrophic injury because at a community event, there was not adequate safety, and they need access to insurance for a life care plan. So it's a super serious situation in that regard. The novelty of this is really worthy of note because the drafting, which I understand was, probably brought as an idea to put forward, takes this anti-SLAPP law, which is really important. It protects free speech. And it says, if you've said something in this hearing that offends someone, if they sue you as a public official for what you said, that is intimidation litigation, trying to silence your speech. And so states have these statutes that say, you can go to the judge and say, dismiss this, because there's a statute that says in the context of free speech, if I'm governing, legislating, leading a public body, I should not be silenced by the threat of litigation. And so the underlying law, anti-SLAPP, it's strategic lawsuit against public participation, is important and valuable. It's a law that protects individuals and organizations from meritless retaliatory lawsuits intended to silence free speech on matters of public concern. What does that have to do with a car crossing the center line and hitting someone, Senator?
I take your point. Circling back to the sort of public officials, isn't there also constitutional immunity that protects public officials' core legislative function from both lawsuit and, in some instances, criminal? Like it's not just the SLAPP provisions, but the Constitution protects our speech on the floor in committee.
That's right.
Okay.
That's right. And I think what the statute, the anti-SLAPP, that's what they're called, it's not me, laws do is create judicial mechanisms for that constitutional right to be protected and actualized expeditiously.
Okay.
And that without that statute, there's no structure for that constitutional right to get quick resolution.
But we do have a level of immunity. Is this proposing a similar level of immunity or an expanded? I mean, we don't have immunity from crossing the center line and hitting someone with our car. I want to be clear. I'm aware of this. But we do have some level of immunity.
And we're not here to quibble with that in any way. So.
But I guess my question is there a way to structure S51 that might provide a board member participating in a board meeting a similar level of immunity without crossing into protecting them from crossing the center line?
Well, we're not here to talk about speech. We're here because someone's been seriously hurt, and the board member, this is the part where, bear with me.
Okay.
Litigation is a bummer for everyone involved. And so let's just put some air into this, because this committee for like 150 years has resisted this type of legislation, and we're the state with the least mingling into this space where we're saying we're going to deny access to justice in this way. But when the person is hurt, here's what happens. You go to an attorney and they say, well, all we know is who hit you. And so we're going to have to bring a suit naming that party and then go into discovery. And this is the part that's hard for everyone, because you're a board member of a philanthropic group, or you were the volunteer who turned away at the event and didn't guard the precipice that the child ended up falling off. Real case. You're now the party that's being dragged into it as litigation goes through discovery to find the right entity to own the liability that has the insurance. And so there are parts of the natural kinks of litigation and that are unfair to people. You're just a board member, or you were a volunteer. You didn't mean this. Maybe you're a volunteer doctor at the free healthcare clinic. Maybe you didn't miss the diagnosis, but there's litigation that's dragged you into it. To create immunity from that party experiencing being part of litigation means you have to do this. Just completely deny access to the courthouse at all. This bill says, expeditiously, the judge will dismiss the case because it's just basic carelessness that caused you to cross the center line and hit the victim. And it's by arbitrary fiat of the statute that they were in service for a nonprofit corporation as a volunteer.
So, sorry, go ahead.
I guess, sort of stepping back, I guess what I'm wondering is if there is a way to narrow the language so it protects the board activity without crossing out of that space.
Well,
No pun intended.
very much understood, and not unfamiliar with this because it does feel like every few years there's a conversation in this committee about nonprofit board members. The entity has insurance that provides litigation defense and recovery for the injured parties. And with Rule 11 in place, Senator, it does not feel that there is unwarranted litigation. I'm trying to articulate that if you're a board member who's dragged into it, it is a bummer. It does feel unfair. It comes with the territory, and it's how the justice system works, because discovery has to go finding what really happened.
So, I think I have two questions here. The first being, when I'm looking at page 3, line 21, for example, in response to some of the hypotheticals here, the defendant's acts caused actual injury to the plaintiff, then the court won't grant a special motion to strike. So, car crossing the center line, even if they weren't texting and driving, it was just solar glare or something like that, and they happened to cross the center line and cause an injury there. The way I would read this is that they're still potentially on the hook. That's the first question, and I think the second question is, if there is some level of discovery that happens and the plaintiff finds out who the higher entity is, what is to prohibit them from pursuing a sort of vicarious liability strategy in their case?
Bear with me, Senator. I'm reading A and B as a conjunction, right? And that it is A2 where negligence is.
Oh yeah, there's the end.
Yeah.
Or
so it's saying that the court shall grant the motion if it was basic negligence and the defendant was hurt.
Yeah, okay, that clears that.
So in that articulation, we come upon the sweeping nature of this bill, and I should say it over and over. The aggrieved party has no real interest in the board members, or, it is about, I know each of you are thinking of a small community nonprofit, and I'm here thinking about large healthcare institutions, major national operations, and or a person who has to get their healthcare at the free healthcare clinic where there are volunteer doctors. And if they miss the cancer diagnosis because you went to a healthcare clinic that was staffed by a volunteer doctor that committed malpractice, you were out of luck. But if you were going to the QHC where the doctors were paid, you'd have access to corporate entity insurance. So there's an inequity in that setting. But I'm here to yellow flag and highlight the sweeping nature of it. It's novel, so we can't find track record in other places. But if you want us to bring in further witnesses, we have folks who are expert at the intersection of slap and injury.
I have to say I'm puzzled by the slap connection. Slap to me seems like trying to prevent malicious prosecution to chill speech. Here it seems like we're talking about a liability issue where someone has injured somebody. So those two things seem so radically different to me. I'm not sure why we're talking about, but
But, well, it's not me, Senator, it's the bill.
Oh, okay.
Because of the
The other thing I'm confused.
motion to strike.
Understood.
Okay,
Are you in favor of the bill or against it?
100% opposed.
Okay, it is impossible for me to tell.
I
From your
understand our associates'
Okay.
expectations when they said articulate the thesis statement at the top.
Yeah.
And I'm gonna give them that on
Okay, so you oppose the bill, and the reason is its sweeping nature and that it would, so you do not agree with these findings as they are laid out here.
that. Yes, but I'm disregarding them for the purpose of testimony because they seem misplaced and.
I'm just wondering because it begins with the assertion, there's been a disturbing increase in meritless lawsuits having the effect of this. I've never heard of an instance of this. So I would want to see some data that bears that out. But I also am having a hard time just understanding what it is that the bill wants to do, except allow a special motion to strike a class of lawsuits.
Correct.
For the reason laid down here. Still confused by the slap.
It's the place where this motion to strike exists. This is immediate dismissal. It's an unusual, it does not exist in personal injury law at all.
Okay.
Anywhere.
Yeah,
And so the concept behind this was to take this tool, immediate dismissal before you've done any discovery and then it drops in. Take that judicial procedure and apply it to personal injury where there's been negligence.
yeah. So I don't buy that linkage. I'm now understanding you don't buy it either.
Correct.
Okay.
Leave it to the English professor to recognize you failed to state your thesis at the beginning of your argument.
Wow. I mean,
Well, when I called it unusual sweeping consequences,
and maybe I missed a walkthrough of the bill where we would hear from the sponsor. And,
We heard from the sponsor last year, when it was initially brought up, and then we heard from an attorney who was in favor of it, Benjamin Brickner. I think that was February 10th.
okay,
last Tuesday.
yeah.
Any other questions while we have this pause? Yeah, feel free to carry on, Adam, if you have additional information you want to share.
I aim to be very simple and clear that this is a can of worms that's unprecedented and an odd construct that has sweeping implications for people that are vulnerable to being hurt, that deserve access to insurance, that this will work.
Thank you.
Thank you.
Any last questions for Adam? Eric, do you want to join us? I'm not sure if you have any responses or thoughts that might be able to help us understand more fully.
Sorry about that. Phone a friend.
I think the friend is phoning him.
Yeah.
I think a lot of what you're talking about is policy decisions, but there's maybe a couple of things I could add just that might be helpful as far as like.
Yeah, if you don't mind, no worries, take your time. If you don't mind joining us as we try to figure out what to do with this bill.
Weren't we striking out section 1 as entirety anyway?
Yeah,
That's
basically, I don't understand the problem or the solution.
do you have this?
I may have in the
That may have been on the day that you were out. So I guess any initial questions for Eric on these policies or provisions before we have a discussion?
Yeah.
Certainly.
Tell me what this bill does again, Eric. 'Cause now I'm completely down left field again.
In the big picture, it allows a volunteer for a nonprofit organization or government entity If that person gets sued, on the basis of their work with the organization or entity, they, can immediately file a motion in the court that basically halts the proceeding against them. And it halts the proceeding, you can see, I know there's a mention of discovery, look at page 3, lines 4 and 5. The person files that motion, discovery is immediately halted. So there isn't gonna be any more discovery in the action. And then the court, look at line 11, has to hold a hearing on it within 30 days, absent good cause. And then, sort of somewhat reminiscent of our discussion this morning in the context of forensic facilities, the burden is shifted. That sort of may ring a bell with folks. The burden is shifted because the court grants the motion unless the plaintiff shows that. So the plaintiff who's filed the suit then has to, instead of the defendant showing that that they didn't act recklessly or grossly negligent, et cetera, the plaintiff has to show it. And if the plaintiff fails to make, you see there's sort of an A and B there, it's kind of what the committee was talking about earlier. The plaintiff has to show either the defendant was acting outside the scope of their responsibilities as a volunteer, or the harm was caused by the defendant's recklessness, gross negligence, or intentional misconduct. So that means ordinary negligence. Would be, that sort of action would be prohibited by this language, assuming that it caused harm. That's the B language in 21.
I'm just wondering, and maybe I've skipped ahead here, but on page 4, it says, if the court denies a special motion to strike and finds the motion is frivolous or is intended solely to cause unnecessary delay, I just can't make my mind work out the connection between this and SLAPP laws. Are there people out there that are deliberately targeting nonprofits in order to use the lawsuit to achieve other ends? Because that's the way I view the SLAPP laws, as preventing people from using the courts to get a desired result that has nothing to do with the lawsuit, which is they want to bankrupt. You know, I'm thinking of, was it, I forget what the online outlet was, but Peter Thiel sued them, I think, and they went out of business. And that seems to me like what SLAPP laws are designed to protect against is a lawsuit that's designed just to bankrupt you or to silence you. Here, this seems like a law where there's been an injury, and I don't understand how the SLAPP applies.
I think it's more of a, yeah, I understand the question. I think the nomenclature of the SLAPP lawsuit was, I would defer that to the sponsor of the
In other words,
legislation.
it feels to me like it's being borrowed as a rhetorical device here, but as a legal matter, it doesn't line up with what SLAPP laws are designed to prevent. There's no equivalent here, or it's hard to imagine somebody using an actual accident to then try to chill the speech of a board or put a board out of business, or I don't know.
Yeah, I think the parallel is structural, not substantive.
Okay.
So in other words, it's the similar type of proceeding that allows the person to go in, they file a special motion, that involves the court proceedings, there can be attorney's fees, and so, you know, that sort of thing is, and a minor detail, but the place it's located in the statutes proposed happens to be also right next to the SLAPP lawsuit. So it's structurally similar. I think you're right, but substantively, it's two different types of concerns that are being addressed with a similar structural legal device.
Yeah. I mean, and not to go too much into that, but it does feel to me like, because periodically we have attempts to halt lawsuits or to declare certain sorts of lawsuits frivolous. This feels like that. So it feels like borrowing the political significance of SLAPP to do something that feels to me as, fully different, and not as popular or not as, I don't know. Anyway,
You look like you want to say something.
Yeah, just not quite sure what I want to say. So what does this bill do in the absence of what the slap law is? Is this repetition? Well, I mean, what is
No,
this?
it's different in the sense of the SLAPP law is about lawsuits involving public officials and people related to their activity in that regard. This is would apply in a different situation, which is a different set of facts entirely, which is that someone that has to do with a volunteer's work for a volunteer organization. So it sort of takes a similar court proceeding from the SLAPP law. Otherwise, has nothing to do with SLAPP. But it takes a similar type of court proceeding. Says, oh, we're going to create that court proceeding for a tort action, a personal injury action, when someone is someone's conduct as a volunteer for a nonprofit allegedly caused somebody harm. Allow them to file this type of motion. That's sort of the SLAPP connection. It's a similar kind of motion, similar kind of court proceeding, but otherwise it's not connected. The only other thing I just wanted to let the committee know, I sort of was able to pull this up, and I think Senator Husky was asking about this in particular. As it happens, there is a current statute that does provide some immunity already for nonprofit board directors, officers, and trustees. That's in Title 12. So that you're, I think, raising that issue. So there is a statute that provides that currently. It's 12 VSA 5781. Yeah.
Yes, I mean, and I heard the testimony from the person, was it 2 weeks ago now?
I think last week. Last week, yeah.
Sure. About this and their concern and why they think this is important, but with the statute Eric just named, I guess what is the problem we're trying to solve if the board members in fact already have some immunity?
I think it's more so trying to get at the uncompensated volunteer work. I get your point, but I think it's trying to get at the person who's, I don't know, driving people to and from, or maybe delivering food or something like that, and getting wrapped up in a larger lawsuit, potentially, that is being filed against the organization at large. I'm not entirely sure. I'm not entirely sure here, but
Okay.
I think that's what it's getting at. I guess my question is, I know there's an infinite number of variables and hypotheticals, but when there's a situation that it's just an uncompensated volunteer who's being sued, how challenging would it be realistically to find out who the employer or the organization is that's supervising the volunteer, so that the injured party can get access to their insurance? I know that if the motion to strike is filed early on, it cuts off discovery unless there's good cause shown. So can you provide a bit more insight into that, if possible?
I think it all sort of depends on how quickly the motion is filed, right? If it's just a matter of the complaint being filed, then the plaintiff may or may not know who the entity is that might have insurance. But they might know. Maybe it's something that they found out sort of anecdotally, or as a matter of public knowledge. Maybe you could presumably, if you're going to file a suit, then you know the facts that happened, you know what organization the person was volunteering for. So perhaps even before you file the suit, which does, I suppose, sort of beg the question of why the action wasn't filed against the entity in the first place. Maybe it was, filed against both, joint tortfeasors kind of situation. But depending on the facts, the person may know already, maybe they wouldn't, I'm not sure.
So I guess my question for the committee is, not that I'm telepathic, but I'm sensing a general indifference to the bill. I don't know if I'm right, or if folks want to spend more time working on this, given we have a week and a half left for crossover, or do we have other priorities that we want to try to get on?
I think that one, I think we have other priorities, I don't. So I don't know that I would qualify my feelings on the bill as indifferent, but if the question is, should we keep working on this? No.
Yes, I agree.
Look at us, Bob, we're agreeing all over the place.
Yeah, maybe a general confusion as well. Because that was kind of my question I had last week when the gentleman came in. I was like, how often does this happen? I don't think it was part of his discovery, if you will, for his testimony, but I've personally not heard of it, so I also don't know if it's more widespread than that. I don't know.
I mean, I've served on nonprofit boards and not heard, like, I feel like if this was a widespread problem, they'd warn you before you joined any nonprofit board.
Yeah.
Like,
I don't know.
Maybe indifference from the right word, but
skepticism.
enthusiasm.
So we may wanna wait to see when you talk about other bills to bring up on the fish to fight, which ones we're going to address before I make a final decision.
I liked it more, Bob, when you just agreed with me.
All right, well, we can just put a pause on this for now, and yeah, we'll just put a pause on it for now.
Okay.
Thank you, Eric. Thank you,
Sure.
Adam.
Yeah.
So committee, we